Your Honor, we would like to call Mr. Powell just briefly.
All right.
If we could call Mr. Powell to stand.
Mr. Powell, do you want to raise your right hand to be sworn, please?
I respectfully decline, for my religious beliefs does not allow me to swear on anything on earth or in heaven.
Do you want to affirm? Do you want to affirm your testimony? Your counsel is shaking his head. Do you want to affirm that the testimony you're about to give will be the truth and the whole truth?
I do, sir.
You want to raise your right hand?
I cannot swear.
He's asking you to affirm. You're
You
being
want to
asked
talk to your,
affirm.
you want, I'm sorry.
I'll leave out the swear part. I'll ask if you affirm.
All right.
Do you affirm that the testimony you're about to give in the cause now before this court will be the truth, the whole truth, and nothing but the truth?
I do.
You may be seated.
Thank you, Your Honor.
Counsel.
Good afternoon, Mr. Powell. Mr. Powell, you've already submitted a couple of affidavits in this matter.
Yes, sir.
So I'm just going to ask you just briefly about a couple of things. One going to the night of August 15th, 2013. Do you recall that evening, Mr. Powell?
I do.
And Mr. Powell, where were you standing when you were sharing your message that night?
I would say about 10 feet from the road, roughly, give or take. I didn't have a tape measure. And on the very edge of the sidewalk, the south of the sidewalk, about maybe 25 to 50 feet away from the ticket booth, and it probably was about 75 feet away from the main gate. 50 to 75 feet.
Mr. Powell, I'd like to show you what's been marked as Exhibit E submitted. The motion is Exhibit E.
From your filings?
Yes, from the files, yes.
You may.
Thank you. Mr. Powell, do you recognize what's depicted in that photograph?
I sure do.
And what is it?
It looks like East 30th and Grand. I would call that the West Gate.
Does that show where you were standing on the night of August 15th, 2013?
It shows the spot, yes, sir.
Can I approach the witness, Your
You
Honor?
may.
I could outline it for you if you'd like.
Mr. Powell, hold on, Mr. Powell, if you would please mark with an X where you were standing the night on August 15, 2013. And make it, I guess, large enough so that it can be seen. May I approach the witness, Your Honor?
You may.
Okay, Mr. Powell, I see an X in the circle. Is that where you were standing that night?
Yes, sir.
Okay. From that position where you're standing, did you note anyone having any trouble walking by you?
No, they plainly walked by me with ease, and, they walked on the sidewalk right past. The sidewalk's pretty wide. It's about like 10 feet or so, There's plenty of room for people to travel on it without being impeded,
And I guess, was there also that night, like it's shown in that photograph, grass in between the sidewalk and the street?
That is correct. That's about 10 feet.
Did you notice anyone who would have to walk in the roadway to get around you?
No, I did not.
Would there be any reason for anybody to walk around the roadway to get around you?
No, the police were directing them down the white lines, They were being directed down that path.
Did you notice any cars come through that roadway on the night of August 15th, Mr. Powell?
Maybe later that night there was taxi cabs and limousines, but at 8 o'clock there was. I don't recall any cars being parked in the little bottleneck area or the little funnel thing right where they shut the gates. I don't recall any.
You recall being stopped, Mr. Powell, that night.
I do.
And what were you told?
I was told to I got to go now.
Were you given a reason as to why you would have to leave?
No.
Were you given an option to be somewhere else on the fairground property?
No, I said I had to go across the street now.
Mr. Powell, were you ever told that you were impeding traffic?
No, never.
Mr. Powell, I also want to direct your attention to the night of August 16, 2013. Do you remember that night as well?
I do.
And I want to show you what is marked as Exhibit G to the previously filed motion for preliminary injunction. May I approach your honor?
You may.
Mr. Powell, well, Your Honor, I would like to enter this, what's previously marked as Exhibit E. I'd like to enter this also as an exhibit that's reflecting the X where Mr. Powell testified he was standing.
Okay, do you want to make it one of your exhibits? It's currently one of the plaintiff's attachments, as I understand it.
It is one of our attachments.
Oh, it's one of your attachments, okay. Is there any objection?
No objection, Your Honor.
Okay, received.
Mr. Powell, getting back to the night of August 16th, where were you standing that night?
There's a little cutout on the I want to say east side of that restroom there. I was standing in the middle of the cutout.
When you say cutout, is that part of the road?
No, it's the sidewalk.
Okay. I believe you heard some testimony about cars that were driving up that street to park. Do you recall that testimony?
I do.
So, were the cars driving up to where you were standing?
No, they were turning before the restroom and parking in the paid parking.
If you would, Mr. Powell, please mark with an X as to where you were standing so as to show where you were standing that night of August 16, 2013. May I, Your Honor? Okay, Mr. Powell, so is that X with a 0, does that show where you were standing that night?
It does.
Okay. Where were you when you were first approached by Officer Orr?
About right there.
Okay. And when Mr. Orr approached you, where were you when you were talking?
Oh, we were about 4 feet from the curb, probably.
Were you still in that sidewalk area?
I was.
Now, adjacent to that sidewalk, it shows a roadway. Mr. Powell, were any cars coming through that roadway that night?
No, they were not. Only golf carts.
When Mr. Orr approached you, did he tell you what his concern was?
No, he told me I had to leave.
Leave what?
Leave the property now.
And by that, what did he mean?
I had to go now.
Where?
He just said I had to go. He never gave me a direction or anywhere. He said I had to leave the property now.
Were you told that you were impeding traffic?
No, not at all.
May I approach the witness, Your Honor?
You may.
No, I'm sorry. Never mind, Your Honor. Your Honor, we would like to enter this known as the August 16, 2013. The X is the next exhibit. Objection, Your Honor.
Received.
I have no further questions. Thank you, Your Honor.
Counsel, would you like to cross-examine?
Yes, Your Honor. On the night of August 16th, when you were approached by a fair security officer, or he told you to come over to him, didn't he?
No, he did not.
Did he tell you anything?
He came up to me and I met him and he said I had to go.
And that's all he said to you?
For a while. At the initial,
I thought you said all he said to you was, you got to go. Did he say more to you than you got to go?
I asked to see the supervisor and I asked him if it was public or private property, but he just kept saying I had to go.
That's all Mr. Orr ever said to you was, you got to go.
Mm-hmm.
Yes?
Pretty much.
On August 15th, when you were approached by the fair security officers, they told you you had to go, they tell you you had to go across the street?
Yes, they did.
But did they tell you anything other than that you had to go across the street?
They told me I had to go. Yes, there was a lot more they told me.
They tell you more than that you had to go?
Told me I had to go or I'd be detained.
And they offered to let you go across the street, isn't that right?
That's correct.
And on neither occasion, we'll start with August 15th, nobody from the Fair Security Patrol told you anything about the content of the sign you were carrying, did they?
Nope.
They never said anything to you about what might have been on your t-shirt, did they?
Nope.
They never said anything to you about what you might have been saying to passersby, did they? And on August 16th, in your encounter with Mr. Orr, he never said anything to you other than keep apparently repeating, you got to go. True?
True.
And he, in keeping with that, never commented in any way on what was on your sign.
Nope.
Never commented in any way on what was on your shirt.
Nope.
Never commented in any way on what words you might have been saying to passerby, right?
Correct.
With respect to the location of the gate at East Grand and East 30th Street, where you were on August 15th, right? Yes?
I mean, what was the question? Sorry.
You were at the location on August 15th, 2013. In the evening, you were at the location of the gate and entrance to the fair at Grand and East 30th, true?
True.
You chose that location because of the large number of people there, didn't you?
That is correct.
You put that in your complaint, didn't you?
Mm-hmm.
Yes?
Yes.
We just have to try to answer yes or no so that we don't get the court reporter too mad at us, okay? In fact, I think in your complaint you allege that you chose the location at the East Grand and East 30, or the Grand and East 30th Street entrance because of the confluence of people coming into that area. Do you recall that?
I do. Yes.
People from different directions were coming together at that location and then entering the fair. Isn't that right?
Yes.
And that's why you chose that location. Yes?
Yes.
August 16th, you go to the entrance off of Eastern University. That's the main vehicle entrance. Would you agree with that?
Yes.
There's also pedestrians coming in to that same entrance.
Yes.
That's the area where cars are parked by the fair.
Yes.
Thousands of cars. Would you agree with that?
Yes.
Thousands of people. Would you agree with that?
Yes.
Again, why you chose that location?
There's a lot of people.
Is it your position, Mr. Powell, that you should be able to go anywhere on the state fairgrounds to preach your message?
I would say the public property.
And for, when you're referring to public property, are you talking to areas outside of the fenced-in area, outside of the paid admission area? Is that what you're referring to?
Yes.
Anywhere outside of the paid admission area, it would be your position, you should be free to go. Is that your position?
Yes.
Regardless of how many people might be there?
Yeah. Yes.
You should be able to do that anytime you wish in those areas?
If it has access to the public.
And is it your position that you should be able to employ any means that you want to express your message to those people at those locations?
Within the law.
What about, wouldn't you be concerned about the safety of people going into and out of the fair?
Oh, I love people. Yes.
That's a legitimate concern, isn't it?
It is.
Thank you. That's all I have.
Any redirect, counsel?
Yes, Your Honor. Mr. Powell, I think I neglected to ask you, on the night of August 16th, where you were standing, being shown in that picture, were you impeding any traffic that night?
Not at all.
Where you were standing, could you have impeded any traffic?
No.
Thank you, Your Honor. That's all I have.
All right.
Nothing further.
All right. You may step down. Mr. Kellum, do you have any other further evidence?
Nothing further, Your Honor.
All right, Mr. Dugdale, I know the burden of proof has gotten confusing here in light of the plaintiff opening by resting on his affidavit and then your presentation and his presentation, but if you want to offer any further testimony and rebuttal, you may do so.
No, Your Honor.
All right.
No, Your Honor. We have no further evidence.
Okay. And Mr. Kellum, at the outset, you wanted to supplement your legal argument. At least that was my impression. Is it still your desire to supplement your legal argument in any way?
Yes, Your Honor.
All right. You may do so.
Your Honor, as a supplement, and I believe it's also as a way of clarifying perhaps what we're seeking here, is that Mr. Powell is seeking to enjoin really three separate policies that have been specified in this case. One is this policy of treating public property as though it is private property, so as to empower the fair authority to dispose unwelcome individuals, and specifically serving as a ban on Mr. Powell's speech. That was reflected on the nights of August 15th and August 16th, as well as the ejection notice that he received that banned him from the duration of the 2013 fair. So that would be one policy of concern. And the next policy would be one that's articulated by the state, and that is, and we've heard testimony about it, and that is this idea of a sort of a general prohibition on things as they would determine it that could possibly impede traffic. So we would, and specifically the way the effect of it is, again, as a ban on Mr. Powell's expression. And as for that matter, any expression outside of the fair portion of the fairgrounds, that it limited speech and expression on public areas outside of the fair itself, the confines of the fair. The third policy is one that, as there wasn't much mention of that today, but it's specified in the brief, raising a concern, and that is the ban on the poles and sticks that would be attached to signage. And so we have a concern about that. Your Honor, with all due respect, we would show that all three policies are violative of the Constitution in the sense that they violate free speech as well as due process. And I'll just briefly go through that, and I certainly don't want to repeat any of the arguments I set out in the briefing. with free speech, so a question here is certainly the forum, because this would go through forum analysis, being a restriction on speech on public property.
Yeah, the briefs, let me interrupt here, Mr.
Certainly.
Cullen, because the briefs by both you and the defendants talked about the distinction between a limited public forum and a traditional designated public forum. Is it your position that this is a limited public forum?
Our position is either traditional or designated. That it's traditional in the sense that because of the way it looks, sidewalks are generally considered traditional public forum. This is public property, the way it functions, where you have uninhibited access all year round, the way it appears. These areas being outside of the fences, there's no signage indicating that there's no entrance in these areas, that these are traditional public fora. An alternative, I believe it could be said, is a designated public forum. If the court finds that it's not traditional, it certainly should be considered designated because there is no limitation. Now, that's different inside the fair. In the fair, and Mr. Slater spoke to this, how booths have to comply with certain things, and there's certain regulations inside the fair. Outside the fair, there are no limitations on particular subject matter or groups. There's no limitations whatsoever. And so it would have to be considered designated public forum if it's not traditional. But in any event, and there may be agreement here, at least the briefing indicated so, is that the standard would be a time, place, or manner standard in judging the free speech restriction. And in going quickly through those policies, I think what's shown here is that, well, first of all, as far as the one with the policy dealing with treating public property like it's private property, the problem with that is it really touches on content and viewpoint because it's all in the eye of the beholder, where an official can decide, well, you're not welcome here, this is our property, you need to leave. And with that, because of the arbitrary nature of it, it necessarily goes into content, and certainly the ban specifically that's been placed on Mr. Powell, he was just told to leave. There is no option to stand aside. There's no option to conduct his speech in any other way. The only option he had was, on both nights, was to leave the property, and of course this was confirmed later with the ejection notice where he couldn't even come back at all. So that's problematic for being content-based. The second policy that was specified in a briefing about trying to prohibit generally traffic congestion and trying to facilitate traffic flow. That in the abstract is certainly a legitimate interest, and I believe Mr. Powell testified to that. That certainly is a legitimate interest. The problem here is that there's been no showing that a person standing there could actually cause any congestion concerns, or they could cause any type of traffic flow concerns. When you take a look at the picture where Mr. Powell is standing, there's absolutely no concerns about anyone walking around Mr. Powell. And certainly when you have this sort of general thing where you can impede traffic, it's not narrowly tailored. You take a look at the Johnson versus Minneapolis Park and Recreation Board case, it's a 2013 case, really dealt with the very same issue where that concern was raised there about public safety and concerns and that was during a festival that took place in Minneapolis. And same type of concerns, that there's a lot of people coming, we really need to be concerned about the safety and where people are walking, and there could be accidents. And what the court held there is that, well, you really can't do that when you're isolating, and this is what they're saying, they're isolating really Mr. Powell's type of activity, and seems where it's under-inclusive in that respect, and it doesn't seem to be geared toward any legitimate concerns when you're just sort of picking certain things like this, including Mr. Powell's speech. And then thirdly, as far as free speech, is the ban with the poles and sticks. There's a case I think is very instructive from the Ninth Circuit. It's the Edwards decision. It's a 2001 decision that dealt with this very issue about the propriety of banning poles and sticks with signs. Here again, without any empirical evidence that could actually cause concern, and we've actually have had none. I mean, really no evidence whatsoever that could be a legitimate concern, that's just not narrowly tailored to any significant government interest. And then in wrapping up, Your Honor, just briefly, and certainly I would welcome any questions from the court, dealing with due process, I would say that's equally a concern here because all these are unwritten. All these rules are unwritten. This idea that they control the property and basically they can oust anyone at any time, giving them an ejection notice as enforced by the Highway State Patrol just because we don't want you there, certainly leads to concerns when it addresses speech, when it deals with speech activity. So while they can say, well, no, it had nothing to do with content, the problem is you have a very blurred line here. You have a very blurred line here because basically they're just saying, well, you have to leave and you're going to leave, and if you don't leave, we'll have the Highway Patrol make you leave. And or you get arrested for trespass, which of course then again reflects the very fact that they view this as private property. And so there's a due process concern with that, where a person is really not put on fair notice that they're doing anything wrong. And certainly there is nothing unlawful about Mr. Powell's conduct on either night. Then with the prohibition regarding traffic congestion, Your Honor, something that I have not cited in briefing, and this is definitely a supplement, is a case of Stahl versus the City of St. Louis. It's an 8th Circuit decision. It's a 2012 decision. And it's 687 F3rd 1038. And that case is important because that deals specifically with this type of law, where in that case it was actually written, not unwritten as we have here, it was actually written where it prohibited activity that could create traffic congestion or could impede traffic. And what the court found, the appellate court found in that case, is that that's just too arbitrary. A person really doesn't know whether they're violating or not. Now, perhaps in some situations, if they're standing in a busy street where you have cars going, perhaps they should know it. But generally speaking, a person really doesn't know, particularly when it could be the reactions of third parties that could be causing the traffic concerns. And so for that reason, in the Stahl case, dealing with this very regulation that they seem to rest on, this unwritten rule, the court found unconstitutional for being violative of due process. And then lastly, with the ban on the poles and the sticks for the same reasons, because it is unwritten, that it's just subject to arbitrary enforcement. Thank you, Your Honor.
Mr. Kellum, the defendants claimed in their brief that the case in terms of defining it within the public forum, they tell me Heffron versus International Society of Krishna, which, as you know, is a reversal of the Minnesota Supreme Court by the U.S. Supreme Court, tells me that a state fair is a limited public forum. Is that the holding of the case?
I think that is a holding, and I think probably what's important to point out about that is it said that the fair, not the grounds outside of the fair, but the fair itself. In fact, if you take a look at the Johnson decision, that's the 2013 8th Circuit decision.
That's Judge Colleton reversing Judge Davis.
Exactly.
I read that case. Yeah.
Exactly.
Yeah.
In that case, they cited Heffron, and they noted that as a limited public forum because of the paid admission. And so that's really the distinction that we have here, is that Mr. Powell is not trying to go inside the fair and conduct his activity. Rather, he stayed outside the fair where there was not paid admission, and that's definitely been the testimony. So in these public areas outside the fair, that's not limited public forum. What would be limited public forum would be the fair itself.
You did not, in your reply brief, on page 18 of the defendant's brief, they say, well, assuming everything the plaintiff claims is true, they don't know what, here's the way I understand their argument, I'm not putting words in their mouth, but they're telling me that none of your request could comply with Rule 65. Rule 65 of the federal rules, as you know, says every order granting an injunction and every restraining order must, and they cite to B, state its terms specifically, and then C, describe in reasonable detail and not by referring to the complainer or the document the act or acts restrained or required. So why don't you tell me, with respect to specificity, what terms of the proposed injunction do you think it would have to contain to comply with Rule 65, and then describe for me in some reasonable detail what it would include.
Thank you, Your Honor. I appreciate the opportunity. With that argument, as I understood their argument, they were saying because it was not written, it could not be subject to an injunction. And I don't think the case law holds that at all. That way, entities could have unwritten, unconstitutional rules and get away with it. It just needs to be specific as to what was applied, and I think that's what I did.
Right. What would I enjoin the defendants from doing?
It'd be from enjoining the defendants from applying the three policies, one being treating the public property like private property, so as to ban unwelcome speech, including Mr. Powell's speech. The second policy is the one they specify themselves. They say this is a rule of theirs. This is so that there can be little question that's a rule. It is unwritten, but there can be no question it's a rule, and that is prohibition against activity that could impede traffic. And so the injunction would be such that it would ban the state from applying that so as to prohibit Mr. Powell's expression. And then the third one would be the ban on sticks and poles that they also specify. That it would be, the injunction would be to prohibit the state officials from applying that so as to keep Mr. Powell from utilizing the banner that he wants to use during his speech.
All right, thanks very much.
All right, thank you, Your Honor.
Mr. Dugdale or other counsel for the defendants, if you'd like to supplement your legal arguments in light of the record we'd made here today, your opportunity to do so.
Thank you, Your Honor. I want to address really what type of forum this is, because I think in essence that's going to depend on the court's analysis of this case. As the court correctly pointed out, HEFRON stands for the simple proposition that the Minnesota State Fair was a limited public forum, not a designated public forum, not a traditional public forum. I believe that decision is controlling in this case, and the facts support that here. And part of what I'm struggling with is the plaintiff's artificial distinction between what they characterize as the public areas outside of the fair and the fairgrounds itself. The testimony that you've heard today establishes that the fairgrounds, or the property included within the fairgrounds, runs from, at least as far as relates here, from the south side of East University and the east side of East 30th Street, if I got my directions correctly. That's where they start. And it shows that, as the testimony has established, that it is set off from the general area. There's a fence surrounding the perimeter. There is no public sidewalk around the outer perimeter of the state fair itself on the areas that it controls and owns. All the public sidewalks exist are on the opposite side of the road, either East University or East 30th Street. There's also the sidewalks and roads that are evident in within the fairgrounds are designed for a simple purpose: getting in and out of the fairgrounds. That is state fairgrounds property. The entire location is state fairgrounds property. This artificial distinction that they're trying to establish isn't factually supported by the record. The record establishes that the fairgrounds includes all of the areas where Mr. Powell was standing. Under HEFRON, then I think that stands for it's a limited public forum.
Okay, Mr. Dugdale, here's the way I got Mr. Killam's response, and again, I don't mean to put words in his mouth, but I thought he told me that there's a distinction between the gated admission portion of the fair and what the record here is established as the parking area.
Well, the gated...
Did you understand his argument that way or not?
that was part of the argument. I'm just trying to, I'm really having a hard time grasping with this, is that they're somehow trying to create an artificial distinction of two different properties within the fairgrounds. And I just don't think it's factually supported by the record, because there's a fence that surrounds it, there's a break in the fence where the public can access the fairgrounds. And then there's fences still around those areas. There is no real distinction between the fairgrounds. Certainly there's the paid admission, but even when you're talking about the area around Gate 15, which is the primary vehicle entrance, people are charging for parking there. We are exercising control. We are limiting what people can do and how they can do it. It doesn't allow people to come in there and park free of charge. The fairgrounds, the State Fair Authority owns and controls that area, and does so during the state fair. That distinction between the public sidewalks outside of it, the paid admission area, is simply not supported by the facts. It's all owned by the State Fair Authority. It's all controlled by the State Fair Authority, and as a result, it constitutes the fairgrounds.
Well, here's what he said, Mr. Kellum. I think that when I asked him about Heffron, he said, I think that is a holding, and I think probably what's important to point out about that is it said that the fair, not the grounds outside of the fair, and that's, I'm continuing, but the fair itself. In fact, and then he tells me to take a look at the Johnson decision, which he and I discussed. So I think what he's telling me is this isn't Heffron because Mr. Powell is attempting to exercise his rights outside the fair.
Okay. And I don't think, again, I think that, I agree that's what he's arguing, and I don't think Heffron makes that fine of a distinction.
Okay.
Nothing in Heffron talked about that fine level, but I do think that what I do think Heffron is that it's looking at what is the designated public, is it a limited public forum? Yes, fairs are limited public forums, and I think it's a reasonable reading of Heffron to say that the areas that the fair controls, which is a part of the fairgrounds, is a reasonable application of Heffron to it. To that, I don't think the Heffron case was looking at that fine of a distinction to do that. And so I think really I don't think that distinction really comes into play. It is the fairgrounds. It is that it was the activities within the fairgrounds. And under these circumstances, under Heffron, it is a limited public forum. And because it is a limited public forum, the government's ability to regulate and control that is substantially greater than in traditional public forums or in a designated public forum. And that we may impose restrictions that are reasonable and viewpoint neutral. And that's really what we're talking about here today, are the restrictions that are at issue reasonable and viewpoint neutral? Let's talk about the first one, which is you can't stand, you can't stand in areas that impede the flow of traffic. First of all, that's viewpoint neutral. It isn't based on the content of speech, it's impeding the traffic. And one of the things I think Heffron really speaks to is the fair's need for assuring the orderly flow of fair patrons in and around the fair. And that is certainly a reasonable one. In fact, as I read Heffron, the U.S. Supreme Court said that the Minnesota Supreme Court minimized the state's interest in regulating and controlling that. And I think they went out of their way to say that was just too narrow of a view of the state's interest in that case. And here the facts show that this isn't an ethereal interest. This isn't just kind of an amorphic concept. As we related to on Gate 11, the main gate, that during those days, those 2 days, basically the city of Sioux City entered and left the state fair. At that main gate, which is the main gate for the pedestrian traffic, which is subject to backup, there has been a year or two before this incident took place, a Des Moines police officer was hit there and critically injured. And a few years before that, a pedestrian was killed there. The concern that we have for the safety is a paramount concern. And one of the things that I think the Heffron Court also provides a good discussion of is the fact that we do not have to, in looking at a reasonableness of the regulation, be limited to just that individual. That they've said that you can look at what impact would that have if more people did it. What impact would that have to do this, to do it? That's part of what you do. If you let Mr. Powell do this, or anyone do it, to be content neutral, it's going to potentially create a situation where that traffic at gate 11 backs up and somebody could get injured. What that point is at any given point in time, we don't know, because that depends on the traffic coming in, going out, all of those issues. But to say that the state fair doesn't have a substantial interest in protecting that safety there, I think is wrong. And I think Heffron certainly gives the state fair the authority to put in reasonable regulations such as that. The same is true on gate 15, which is the one up on the main vehicular entrance. There's a dispute in the testimony on what happened, but Officer Orr testified that when he arrived at that scene on August 16, that Mr. Powell was standing in the street in the street, impeding the flow of traffic. Standing in that location there where there are really mainly all of the thousands and thousands of vehicles are parked with people going in through that area poses a substantial interest that the state should be able to take reasonable steps to do it. And to say you can't stand out there or impede traffic so people could potentially get hit is a reasonable governmental interest to do that. We don't have a problem with Mr. Powell's speech. We had a problem of where he chose to stand and the problems that him standing there caused. Now, that's really, I think, with the limited public forum, and I think the reasonableness of those regulations are there. One of the things I do want to address with regard to the ban on poles and sticks. One of the issues is, and in their reply to our resistance, they made the notion that there's that we allow corn dogs and on a stick and food on a stick, that poses an issue. Here, the concern of bringing in a pole that could be used in a situation is a legitimate concern. Whether someone would or wouldn't, we want to regulate what goes into and onto our premises that could be used as a weapon. Again, we don't know what's going to, whether it will, but it's a reasonable approach that when you have over 1 million people entering the state fair over the duration of the fair, to make sure nothing goes wrong. And that's a reasonable issue. I do want to address the issue of the injunction to what they would have to try to enjoin. We're, in looking at this, even though their complaint doesn't address it, or their motion for doing this, creates some issues, and we still have concerns.
Well, Mr. Dugdale, isn't the reason for the rule the very due process reason that counsel hit on, that if you have a vague, you must obey the law injunction, that gives a lot of arbitrariness to law enforcement, and that's why the rule itself requires specificity. Isn't that the reason for the rule?
Well, this is the problem that you're having is that how do you assess the reasonableness of it in the situation? Part of what you have here is, given what the court said in Heffron, is that it's really hard to know when that tipping point is to do that. So, it's really hard to say one person, but we're going to have many people there potentially doing it. It's such a fact-specific inquiry.
Right. Your answer, Mr. Dugdale, is like many legal answers. It depends.
Yeah, absolutely. And it depends on the facts. And I think that's part of the issue that we have here. They want us to basically comply with the law, but it is entirely fact-dependent. And it creates an issue. Certainly, I have from one perspective, saying that we cannot have a rule that says that we cannot prohibit activity that would cause congestion. That's certainly, that would mean that we had no ability to ensure the safety of people. We couldn't say, move along, get moving, take it, even if it was a person setting up a card stand and selling lemonade. We can't tell them, you got to move it because it's causing an issue. We have to be able to do that, and trying to define a standard by which an injunction could work is problematic.
So here's what you tell me in your brief, and tell me if you need to supplement this. You say on page 18, you say the defendants are unable to identify what, if anything, the court would enjoin the defendants from doing this case because plaintiff's complaint fails to challenge a written rule, written statute, rule, or policy. But if the record is such that they've shown that he was deprived of his appropriate First Amendment rights, you do concede the court could issue an injunction.
Well, again, the issue that I have is how do we say it? Because the inquiry is inherently fact-specific. We will want to talk about the inherent fact-specific nature of the inquiry. That's the problem that we have is that, if it was a situation where truly the traffic was backing up, we have video camera, we could do it, we'd be prohibited from doing it. That's part of the problem that we see with how the enforcement or that prohibition or the injunction would deal with. It would create, in effect, the state fair's inability to regulate ingress and egress to the fair. And I think that because it's so inherently fact-specific, that's really the problem that we're focusing on here, is that all of these issues that they're asking for are basically comply with the law because it's so fact-specific to do this, that to be able to go through it. That's the problem we have with both the due process issue and in particular with the injunction to do that. So from our perspective, there are substantial issues of compliance with an injunction to do that. Because unless you have any further questions, I think that concludes my remarks.
Thank you, counsel.
Thank you.
All right. We'll consider the matter submitted. We'll be in recess.
All right.
And by the way, before we I'm going to have my IT department post this unless one of you give me a compelling reason why we shouldn't post it. Hearing none, I'll tell the IT department to post the video on the website. We'll be in recess.